Homicide, Lecture 10. This is the first in a series of lectures dealing with the actual substantive law or criminal violations. 4 elements of homicide include the killing of a human being or fetus by human act or agency when death occurs within 3 years or a day. Although the act need not be the only cause of death, it must be the proximate or direct cause of death. The death must occur within 3 years and 1 day after the cause of death is administered, or it will be rebuttably presumed that the death did not result from the act. And this is covered under PC 194. When we look at killing, the definition of death is when the person is brain dead. Total, irreversible cessation of brain function. Because we know that people can be kept alive on different types of medical devices, this is the requirement by law. An interesting note is that a doctor who produces a death certificate and pronounces death can't be associated with the removal of body parts of a donor, so it doesn't become some sort of an assembly line process. Officers may search the body of the deceased or accident victims for donor cards only. Other than that, the coroner is supposed to be doing the searches. It's another thing that you should know. The definition of a human being or fetus is that it's a living human when it has its own independent circulation and it's not relying on the circulation of the mother. The umbilical cord need not be severed for this to be a fact. The baby must be able to survive on its own, or the fetus must be able to survive on its own. So if you think about the Scott Peterson case, in that case there were 2 counts of murder charge because the baby obviously had a circulatory system that would be determined by the coroner's inquest. Has to be by human act or agency, not an act of God. Person can't be hit by lightning or kicked by a horse or something like that, because it wouldn't have been a human act. It would have been the act of an animal. The proximate cause. When we talk about proximate cause, it's if the original act had not occurred, would the victim have been in a position where they would have died? Meaning that if you punch somebody and they're hemophiliac, they're a bleeder, and they pull themselves into a bathroom and lock the door and bleed to death, you still would be responsible because it would be your initial act of striking them that caused them to bleed out and die. When death occurs within 3 years and a day after the initial stroke or cause of death is administered. Used to be 1 year and a day, however, advances in medicine have prompted the change. Mitigating circumstances and burden of proof on the defendant if the person dies within that 3 years. Let's say they get in a car crash and it reopens a wound in the stomach, and you're able to show evidence that it's the car crash that killed the person, not necessarily the initial stroke from the original crime. Again, really quickly, when we deal with the corpus delicti here, the body of the crime, we know that that's essential to the elements of this offense. And corpus delicti, again, is the death of a human being, And the second element is an unlawful act, omission, or criminal agency causing the death. Remember, it's one of the things that applies here is it's not necessary that there's direct evidence to be used to accomplish a killing. You can prove corpus delicti by circumstantial evidence. In other words, I had a case one time where I had a missing person case, and I had the person was last seen in a certain location, went to that location, and there were approximately 4 liters worth of blood on the ground there, but no body. And we were able to show through circumstantial evidence that in that case, a person could not have lived losing that much blood. So we were able to establish that a homicide had occurred. The breakdowns of homicide in California include unlawful homicide, murder in the first degree or second degree, manslaughter, which could be voluntary, involuntary, or vehicular. Murder, PC 187. This is the unlawful killing of a human being or a fetus with malice aforethought. Malice aforethought does not necessarily mean an actual intention to kill the deceased, nor does it necessarily imply deliberation. Rather, it indicates a purpose and design as contrasted with accident or misfortune or mischance. It's present when there is an intention to cause death or grievous bodily harm, or knowledge that one's acts will probably do so. Malice does not mean hatred or personal ill will toward the person killed, nor the actual intent to take the victim's life, or anyone's life for that matter. Thus, if the killing was for the purpose of robbery, without any hatred or ill will against the person killed, it would be homicide under the felony murder rule, which we'll cover in a second. Again, malice can be expressed. It can be deliberate intention to unlawfully take a life, or it can be implied where there's no provocation and it's done with an abandoned or malignant heart, cold-blooded killer. Acts that establish murder: willful or deliberate and premeditated killing, or a statutory violation where the intent to kill is not required. That's a felony murder rule. Wanton, irresponsible acts. And for the purpose of terminology, willful is a purpose or willingness to commit the act or omit the required act. Premeditation means to think about and resolve in one's mind before doing. Deliberate means that the purpose was formed or arrived at as a result of careful thought and the weighing of various considerations. First-degree murder: willful deliberation and premeditation, meaning you planned it, you thought about it ahead of time. Or if the person uses explosives, a destructive device, an explosive of any type, or armor-piercing ammunition, and this could include a Molotov cocktail, which is gasoline in a glass container that can break with a wick, which is made usually out of gasoline-soaked rag, so that when the glass breaks, the fumes cause a big explosion when it hits the fire on the wick. So explosives are premeditative because you have to set them. Torture: kicking a helpless person for 15 minutes to death. That's one of the cases that I'm citing there. Poison: again, you have to administer poison. You have to give it to the person, so therefore you have to plan it. You have to premeditate. Or lying in wait. This is one of the oldest classifications of murder. Bushwhacking, waiting behind a bush and hitting somebody in the head. Example I give is defendant waiting in a cabin for the victim with a loaded rifle. Now we have another area where it's statutorily applied as murder one, and this is called the felony murder rule. The felony murder rule, any of these listed, burglary, arson, rape, robbery, mayhem, carjack, kidnap, train wrecking, sodomy, lewd acts with a child, or forced oral copulation or drive-by shooting. If you commit one of these crimes and you hit an innocent bystander or in any way someone loses their life, you could be guilty of first-degree murder. Now, an example would be that you go in to do a robbery on a bank. So you go into the bank, and when you go into the bank, Mrs. Jones, who's an elderly female who's at the teller counter, sees that it's a robbery, has a heart attack, and dies. You could be responsible for that murder as a murder one case. Now, an easy way to remember some of this is to use the PET Poly method, which is P for premeditated, E for explosives, T for torture, PO for poison, and LY for lying in wait. For the felony murder rule, remember mad cats bark. And this is MA for mayhem, D for drive-by, CA carjacking, T for train wrecking, S for selected sex crimes, B for burglary, A for arson, R for robbery, K for kidnap. Helps you memorize these things. Penalty for first-degree murder is death or life without parole or 25 years to life. Under PC 190.2 first-degree special circumstances, this is where, when we say special circumstances, we're talking about a capital crime where the perpetrator could be put to death. This includes the areas as follows: murder for hire, a first or second degree previous conviction, use of destructive device, if the homicide is committed to avoid lawful arrest, if the victim is a peace officer, if the victim is a federal officer, if the victim is a firefighter, if the victim was a witness to a crime, if the victim was a prosecutor, if the victim was an elected official, which could also include a judge, if the murder was extremely heinous or cruel. And that was found to be unconstitutional because you have to, again, describe what is heinous or cruel. It can't be something that's vague. Lying in wait, hate crime, felony murder rule. We already gave you some of those. If torture is used, if poison is used, if it's a targeted juror, or if it's a drive-by shooting, all of these are special circumstance cases. Second-degree murder is where the killing is not premeditated, but there's a strong possibility the action could cause death, and there's disregard for this info. So it's any death in association with any felony not under the felony murder rule. This would include someone giving somebody their first taste of crack cocaine, and the person has a heart attack and dies, because providing the crack cocaine is a felony. A pedestrian hit in a 10851 hot chase. 10851 VC is the vehicle code section for auto theft. So you have an auto theft, which is not listed under the felony murder rule, but it is a felony, and you're chasing the person. You're chasing them in a hot chase in a car, and they hit a pedestrian, and they kill the pedestrian. That would be a second-degree murder. Inherently dangerous misdemeanors like abandoning a child on the freeway. Another example is where we had a case in Berkeley where two parents decided to celebrate because they had a baby. Baby had a little bit of a cold and a little bit of a fever, and the two parents got high, passed out, and the baby died because they didn't pay attention. Penalty for second-degree murder can be 15 years to life, 25 to life if it's a peace officer, and 20 to life if it's a drive-by shooting. PC 192, manslaughter. Now, manslaughter is different than murder because there's a heat of passion. We have voluntary and involuntary. Now, involuntary, let's say that Mrs. Jones comes home and finds Mr. Jones, who is back in the bedroom with another female, and she catches him in bed. She reaches into the top drawer of uh, the dresser where she knows her husband has a loaded revolver, pulls it out, and empties the gun into the bed, killing both of the people there. Now, this would be considered heat of passion. She's very upset. She didn't get a chance to think about it, and so it's not considered murder one, but it's voluntary. Involuntary is where two guys get in a fight, and one guy pushes another one or punches him, and he falls in front of a passing car. Now, he didn't mean for him to fall in front of the passing car. Or it could be a commission of a lawful act, but in an unlawful manner without due caution. A hungover hunter shoots the other hunter because he's hungover and he's still partially intoxicated. Failure to perform a legal duty. Let's say that in the case I talked about providing medicine to an infant because you're drunk, you forget to do that and the infant dies. Now, when we look at these manslaughter cases, especially when we look at voluntary, if I want to go back and talk about the fact that if you have the same situation, Mrs. Jones, right? She catches him in the bedroom. She goes into the living room. She's watching Oprah Winfrey, or she's watching Jerry Springer, and she sees how, something has occurred that's on there where she's viewing a case where maybe somebody lit somebody on fire. So now she sees this case and she goes down to the gas station. She buys a gallon of gas. She goes to the local hardware store. She buys a bucket because she knows the gas is going to come out of the gas can too slow. She needs to pour it into the bucket so she can douse them and light them on fire. These sorts of things are premeditation. And these sorts of things, we talk about a cool-off period. When you have an initial shock and you react to it. That's one thing, and that would be manslaughter, heat of passion. But when a person has a chance to sit back and think about their actions, or they premeditate now, as in this case, this would bump it back up to a murder case from a manslaughter case. Vehicular manslaughter, a little bit different here under 192C1. If the person is under the influence and they're driving crazy, gross negligence, or commission of a misdemeanor, or any combo of the three. There's a case called Thompson that is available for you to review. And in Thompson, the driver is in Santa Cruz, and she is high on methamphetamines and marijuana and alcohol, and she has a passenger in the car. And the passenger and her continue to change driving positions. In other words, he'll drive to go to one bar, and then she'll drive to the next bar, and they're getting drunker and drunker and drunker, and eventually she is speeding, goes over the double yellow line, is speeding in a mountainous area, and she loses control of the car, and as a result of that, the passenger in the car is killed. So in that case, when you look at it, she's under the influence. The gross negligence is shown by the fact that she committed 3 different vehicle code violations: speeding in a mountainous area, going over the double yellow line, which would be considered reckless driving, which would be gross negligence, and also would be considered a misdemeanor, and so she would qualify for the felony. Now, if she did everything the same as above, she was just intoxicated, but she was driving normally, and the same thing happened, it might be considered a misdemeanor. And in 192.3, felony is the same as above, but under the influence. So again, you can have with gross negligence, without gross negligence, or under the influence, but not under the influence. Punishment for manslaughter, both voluntary and involuntary manslaughter, are felonies, punishable by imprisonment in state prison. Vehicular manslaughter is a wobbler, except for the misdemeanor section I talked about earlier. where you do county jail time. Now, are there lawful homicides? Homicides that would not affix a penalty of prison, death, or county jail? Yes, those include excusable accidents or misfortunes. You've heard probably of workers who fall from high heights and die, or cranes that fall down on them, or toolboxes that fall on people, or people that fall into vats of chemicals at various work areas, or someone who might die in some sort of industrial accident. Those could be considered excusable as long as they're accidents. There's also justifiable, where police are allowed to use deadly force to defend themselves, and also court ordered, where somebody's ordered to be put to death. Citizens also have a right to self-defense. So excusable, again, homicides would be there's no intent to kill. This is misfortune or accident. There's no law violated. There's no lack of due caution, and it's by accident or misfortune. Could be a situation. I know of one case, again, in my police experience, where a lady shot her son coming in a bedroom window. He was surprising her. He'd gotten emergency leave from the Navy. He was not supposed to be home, and she heard some noises, dogs barking. She goes and sees a silhouette coming in the window and fires. And in that case, she was scared for her life. She thought it was an intruder, and it was an accident, so it was deemed to be excusable. Now, justifiable homicide, again, arresting or retaking felons. There's a couple of cases that are out there. Peterson versus City of Long Beach is the presiding case in California. Deals with fleeing felons. Now, fleeing felons, the rules are, before you can shoot, you have to, first of all, know that it's a felony, have probable cause to believe it's a felony. Number two, believe that the person's armed. And number three, believe that they're a danger to the officer or the community. And in this case, I can give you an example. In Berkeley, we had a situation where the suspect had just robbed a store, had come out, actually had the bank bag in his hand. Very distinct description of the suspect, including an overcoat and armed with a .45 automatic. And when officers arrived at the scene, they had him boxed in the back parking lot. He comes out from underneath the car. Obviously, he's hiding under the car. He crawls out. He starts backing his way toward about a 3-foot high cement wall. Now, on the other side of the wall was a residential neighborhood. You could see about 3 doors down, a lady was actually hanging her clothes on a clothesline in the backyard. So the officer told him that if you go over that wall trying to escape, I'm going to have to shoot you because you're going to pose a threat to the woman over there. We know that you're armed. And as a result, the suspect tried to go over the wall and was shot. And later on in a hearing, the citizens that were in the area testified to the fact that the officer had warned him that he felt he was going to be a danger to the citizens in that residential area. And it was shown to be a justifiable shooting. Other ways that officers can use deadly force is in the obedience of a court-ordered execution, where the judge orders the execution of a convicted felon. That person will go to Department of Corrections, and Department of Corrections is responsible for pulling the switch on that person. In this case, it would be lethal injection. Officers also have the ability to defend themselves, overcoming resistance to execution of legal process or duty. If someone is attacking an officer or puts them in a position where they feel that they could be severely injured or put to death, they can use deadly force to defend themselves. Justifiable homicide in general, as it applies to citizens, is when resisting an attempt at murder or any other felony where great bodily injury could occur. So if someone's chasing your daughter around the front yard with a baseball bat, threatening to kill them, you could use deadly force to defend your family member. Defense of habitation. This includes one who intends by violence or surprise to enter the habitation of another to commit a felony. A lot of people don't realize that under 601 PC, it's felony trespassing if someone calls you and threatens you, and within 30 days of that call shows up at your doorstep with the apparent ability to cause injury to you, then you could use deadly force to defend yourself. So if they just show up there to talk, obviously you can't use deadly force. But if they show up there and they have a knife, or they have a baseball bat, or they have an axe, or they have some way of injuring you, you could do it. So it's entering the habitation of another to commit a felony, or intend violence, or intend to enter a location for the purpose of offering violence to any person inside. You don't have to retreat, and no warning need be given. Killing of trespassers. Trespassing alone is a misdemeanor, doesn't warrant the use of deadly force. There's a misconception among the public that you can use deadly force on trespassers. You would be convicted of manslaughter, voluntary manslaughter, and possibly even second-degree murder, because you cannot use deadly force on a property crime. Self-defense. You can defend yourself, and I try to break it down to 3 characteristics that need to be there before you can use deadly force. First, the 3 are ability, opportunity, and jeopardy. The person coming at you has to have the ability to injure you. They're armed with a weapon or with force likely to commit great bodily injury. So the person's armed with a baseball bat. Let's use that as an example. The second part, opportunity, means they got to be in range to use that weapon. They can't be, 50 feet away from you. And the last thing is they have to put you in jeopardy. They're in motion to attack you with it, or they're swinging it. Something that you can articulate that shows that they were going to use this weapon on you. And if you meet all 3 of those requirements, then you'd be justified in using a deadly force. Now, self-defense, remember, the burden of proof is on the defendant to show that they were in fear of their life, and that a rational, normal, reasonable person would have also been in fear of their life. Things to remember. There's got to be a possibility of great bodily injury. That bare fear alone is not enough. It's got to be, in other words, if you have a warehouse and an alarm goes on and you're walking through the warehouse and you hear a noise and it startles you and you shoot toward the noise, you haven't identified what it is that's making you scared. So that's bare fear. If you look and you have a guy who's, loading and locking a rifle pointed at you, that's a whole different matter. But at this point, you're shooting at a dark area. You don't know what it is that you're shooting at. That would be bare fear. Although you're scared, you haven't identified what it is you're scared of. Previous threats alone can't justify using deadly force. Because somebody has told you they're going to injure you. Remember, I talked about the fact that somebody said they're going to kill you on the phone. They show up at your house. They want to apologize. You couldn't use deadly force on them. If they show up at the house with the means to carry out the threat, that's a whole different issue, and you'd be able to defend yourself. Overt acts can't be created by the slayer. You can't goad the person on. In other words, I pick a fight with a guy, and when he comes at me, I pull out my gun and I shoot him, and I say it's self-defense. You can't do that. Amount of force is limited by the circumstances, the age, the size, what it is they're using against you. All of those things have to be dealt with before you're going to be able to use deadly force. And it's not going to be the same in every instance. You may have a 12-year-old kid with a garbage can lid that you think you can disarm, where if you had a 28-year-old with that garbage can lid and he smacks you upside the head a couple times, it might kill you. So you have to look at these things on a case-by-case basis. Once the danger is past, so has the justification. The instigator in a fight loses the right to self-defense unless you're fighting with somebody that you picked a fight with. They're beating you senseless. You say, I give up. Please stop. And they don't. And at that point, you have to go to a higher level to defend yourself because they're going to kill you. Or a peace officer, because a peace officer is, under law, is required to carry out their duties. So they never give up the right to self-defense. Now, if you look and follow the tree that's listed in front of you, you can see that you have a couple of things you can look at. If you start at the very base of the tree, you have homicide, death of human or fetus, human act or agency, 3 years and 1 day. If you go to the right, look at the question above it. Was the law violated, or was there a lack of caution? If the law was not violated and there was no lack of caution, it's probably a lawful homicide. Continue to the right. Was the killing accidental or with no intent to kill or injure? If the answer is yes, then it's excusable, meaning that you didn't mean to kill the person. Something, you were working on your roof, your toolbox fell off the roof and it hit the person in the head, killed them. If the answer is no, it's justifiable, meaning that was it accidental or was there no intent to kill? No, you meant to kill them. The person came in your house, they grabbed a knife, you pulled your gun out and you blew them right out of their shoes. You intended to kill them. That's justifiable. Go back down to the base of the tree and look at where it says, was the law violated or was there a lack of caution? If the answer is yes, it's an unlawful homicide. Was there an intent to kill or injure? Then the answer is no, then it's a manslaughter. Was a vehicle used? If the answer is no, then it's involuntary, meaning that you didn't mean to injure the person. You were in a fight with them, you punched them, they hit their head on the corner of a table and die. Was a vehicle used? If the answer is yes, then it's vehicular manslaughter. And you already know that the difference between misdemeanor and felony mostly has to do with whether there's gross negligence and also if they're under the influence. Go all the way back down to unlawful homicide. Was there intent to kill or injure? The answer is yes. Did it involve heat of passion? If the answer is yes, it's voluntary manslaughter. If the answer is no, then it's murder. And then we get into our felony murder rule, or the listed first degree requirements. And if they don't meet that, then it's second degree.